Hey everybody, Matt Johnston here. I have another legal update, an interesting issue this time. Here in my town of Frederick and in many other towns and cities across the country, there's been a number of protests and collections of people and yes, some rioting and looting. I'm not going to talk about the content of those. If you want to know what the contents of those events are, you can certainly read up on them. It does have to do with issues of Black Lives Matter, structural racism, things of that nature. What I did get an interesting question on was, what if I have an employee who was on COVID-19 related leave, be that the federal paid sick leave or the EFMLA, and chose to attend and publicly post about their activities at a protest? Now that is an interesting question. See, it's fraught with a number of different problems as we look at it. The first is, was the leave taken on pretense? Second, is that kind of activity permitted? Third, what does an employee, or rather, what does an employer have as an obligation to protect the rights of individuals to engage in free speech? And finally, is it fraud? Is it some sort of lie that an employer can discipline an employee about? So let's take a step back and look at a few things. Number one, if an employee is taking company provided paid time off and there's no requirement for the reason for the time off, if an employee says, I'm going to take Friday off, I'm going to go, and they don't have to give a reason outside of anything that the employee requires to give. So, for example, I'm taking a day off. I have 15 days available of leave. I've got 9 in the bank. I'm choosing to take a day off. And I've made the request in advance in according to all of the policies provided by the employer. The employer has very little control over what the employee can do on that day off. In fact, almost none. But what if the employee has decided to take or has needed to take COVID-19 related time off? Now that is a different kettle of fish. You see, the reasons for COVID-19 leave, whether that's the paid federal sick leave or the EFMLA, is directly related to COVID-19 related reasons. So whether the person is being treated for or obtaining treatment for COVID-19, whether they're under a quarantine order or they're caring for somebody under a quarantine order, that leave is for those specific reasons. If an employee is on EFMLA, the reason is supposed to be because the school, that employee's children can't go to school or can't have childcare for COVID-19 related reasons. So if the employee is taking one of the days that they're off to engage in a protected First Amendment activity, what is the employer's obligation? Now, from one argument that you can make is that, again, an employer can't have much to say about whether or not to grant that leave. But is it fraud? Is it saying, well, I was taking it for this, but I'm not really using it for that. I'm taking the days off because I have a COVID-19 related reason, but I'm not really going to use it for that. I'm going to do it for something else. The question then becomes is whether or not the employer is required to compensate the employee. If you remember, federal paid sick leave and EFMLA does come with some paid stipulations. Now, the benefit, of course, is that the employer gets to take the tax credits related to that payment to the employee, but it does present an interesting question. So here's my advice. I would certainly sit your employee down in a phone call and say, hey, look, we're not denying your right to do that, but you weren't exactly clear with us, and you were engaging in behavior that jeopardizes our ability to get the tax credits. Because if an employer submits a statement to the government saying, I paid this employee, say, $300 for this day because they were on paid sick leave, and it turns out that the employee wasn't actually at home, is that fraud upon the government? arguably, yes, you're making a statement under oath that says, I use this money for this purposes, and I am now claiming a tax credit. So it becomes a question of who's lying to whom. And my advice would be for the employer to say, we're going to dock you your paid time off for the day, but not use that for tax credit purposes. It's the most conservative way of going about doing things, and in the end, it allows the employee to still engage in what they were doing. Now, of course, if the employee doesn't have paid time off available, the employer could say, we're simply not going to pay you for that day. So be mindful of that. It's not a question that I think is going to be commonly coming up, but it is a real question. And while employers should at least passively support their employees' right to speak on issues of public matters, and arguably actively do so, it is one in which you do have to be careful about not compensating employees for their political activities. So in the meantime, I hope everybody stays safe. If you have questions about this particular topic, please consult an attorney before you take any action, before you do anything like docking pay and things of that nature. Consult with an attorney. But in the meantime, stay safe, and we will talk to you later. Bye-bye.